Under Article 2, a breach of contract occurs when one party fails to perform its contractual obligations. Generally, a breach occurs after the time for performance has passed. However, Article 2 recognizes the unfairness of forcing one party to perform when it has reasonable grounds to believe that the other party can't or won't perform. To address this unfairness, Article 2 has adopted the concept of anticipatory repudiation. Generally speaking, anticipatory repudiation is a breach that occurs before the actual time of performance. Although anticipatory repudiation was initially developed under the common law, Article 2 refines the concept and incorporates several provisions allowing the non-repudiating party to demand adequate assurance, suspend performance, or treat the contract as terminated. Article 2's rules regarding anticipatory repudiation apply if a party repudiates the contract before performance is due, and the repudiation substantially impairs the contract's value to the non-repudiating party. Let's take a closer look at each of these elements. A repudiation occurs if one party reasonably indicates to the other party, through either words or actions, that it can't or won't fulfill its contractual obligations. Imagine that an artist contracted to purchase 20 shipments of paint from a supplier. The artist accepted and paid for a few shipments, but soon determined that he wasn't making enough money due to the high cost of materials. The artist and supplier discussed a price reduction, but couldn't reach an agreement. Eventually, the artist told the supplier, "I can't buy any more paint from you unless you lower the price." Here, the artist repudiated the party's contract. In light of the parties' failed negotiations, the artist's statement was a clear, unequivocal statement of his intent not to perform. Contrast this with another scenario. After accepting and paying for a few shipments, the artist told the supplier, "It's difficult being an artist. If I can't sell my paintings for more money, I'm not sure I'll be able to afford your paint." Here, the artist's statement wasn't an anticipatory repudiation. The statement didn't clearly, unequivocally state the artist's intent not to perform. Rather, it merely expressed doubt about the artist's ability to perform. Finally, let's say that shortly after entering the contract, the supplier's sole paint factory exploded and was destroyed. Here, when the supplier lost its only factory, it immediately repudiated the party's contract. Although the supplier didn't make an overt statement of unwillingness to perform, losing its only factory made its performance impossible. Actions that make performance impossible are just as much a repudiation as words that clearly indicate an unwillingness to perform.